Hello, everybody. I'm going to give it about 30 seconds or so and we'll get started. All right, good afternoon, everyone. Welcome to the Environmental Law Institute's webinar, analyzing the EPA's proposal to list PFAS chemicals as hazardous substances. My name is Madison Calhoun. I'm the Senior Manager of Educational Programs here at ELI. I wanted to give you a warm welcome to today's event and to thank you so much for joining us. We appreciate your time. I also want to give a huge thank you to our fantastic speakers who have put in time and energy into preparing a great program for you all today. Thank you so much for being here. The format of today's event is as follows. I will turn things over to our moderator momentarily, who will introduce the panelists and give some opening remarks. After that, there will be presentations from each panelist, followed by a roundtable discussion with time at the end reserved for an audience Q&A session. However, we will also address any questions related to each panelist's individual presentation as they come up, rather than holding those specific questions until the end. So if you have any questions, please put them in Zoom's Q&A box as you think of them, which should be at the bottom of your screen. Should you have any technical issues during the webinar, please message me or send an email to calhoun@eli.org. And with that, I will hand things over to our wonderful moderator, Leland Frost. Leland is a member of Alston & Bird's Environment, Land Use, and Natural Resources Group. His practice covers litigation and appeals, enforcement, risk assessment, compliance, investigations, and regulatory counseling. Leland previously practiced law in the DC office of another global law firm, and before that, he was the Associate General Counsel for the National Association of Manufacturers. Leland received his JD from Vanderbilt University Law School, where he served as an editor of the Environmental Law and Policy Annual Review. Over to you, Leland, and thank you all so much.
Madison, thank you very much for that introduction and the discussion about the Q&A process. We're thrilled to have three panelists joining us today, and I will introduce them here briefly and then turn it over to them for their presentations. First, we have Dr. Rashmi Joglekar, who is a staff scientist at the environmental law nonprofit organization Earth Justice. She works in Earth Justice's Toxic Exposure and Health Program and is based in Washington, D.C. In this role, Dr. Joglekar synthesizes scientific material for use in legal advocacy aimed at strengthening agency action and risk assessment of toxic chemicals. She has drafted comments on agency proposals, coordinated expert testimonies for legal cases, and advocated issues regarding toxic chemicals through blog posts, public databases, reports, and op-eds. She has also presented to multiple federal agencies and served on expert panels to advocate the need to examine cumulative exposures in highly exposed and susceptible communities. Dr. Joglekar received her PhD in toxicology from Duke University with a research focus on neurodevelopmental toxicology. And also joining us today is Simone Jones, who is an environmental partner at Sidley Austin's Washington, D.C. and Chicago offices. And she is one of the leaders of Sidley's Environmental Justice Group. Her practice includes defending clients in environmental and toxic tort litigation and product liability matters, and representing corporations and executives in internal and criminal investigations. She represents clients in various industries, including the chemical, automotive, and refining sectors, and she leverages her prior work experience at a multinational healthcare company to represent pharmaceutical companies in their most important matters. Simone is defending and advising companies in emerging contaminant matters involving PFAS and other substances, and other recent cases include defending original equipment manufacturers and senior executives in matters involving auxiliary emission control devices, fuel economy, and onboard diagnostics. Simone earned her JD from Chicago Kent College of Law, and she earned her Master's of Public Health from Tulane University, and her BS in Biology from the University of Arkansas. And finally, joining us today is Lynn L. Bergeson, who is managing partner of Bergeson and Campbell PC, a Washington, D.C. law firm focusing on the Toxic Substances Control Act, otherwise known as TSCA, Federal Insecticide, Fungicide, and Rodenticide Act, known as FIFRA, the European Union Registration, Evaluation, Authorization, and Restriction of Chemicals, also known as REACH. Lynn counsels corporations, trade associations, and business consortia on a wide range of issues pertaining to chemical hazard exposure and risk assessment, risk communication, minimizing legal liability, and evolving regulatory and policy matters pertinent to conventional, bio-based, and nanoscale chemicals. Thank you all very much for joining us today, and I will turn it over to Rashmi.
Thank you so much, Leland, for that kind introduction. As Leland said, I'm Rashmi Juglaker. I'm a staff scientist for the Toxic Exposure and Health Program at Earth Justice, which is a nonprofit public interest environmental law organization. I'm really thrilled to have the opportunity to speak with you all today. So to jump right on in, CERCLA, or the Comprehensive Environmental Response, Compensation and Liability Act, creates a scientific standard that authorizes EPA to designate as hazardous substances, such substances which, when released into the environment, may present substantial danger to the public health or welfare or the environment. And as EPA correctly found in its proposed hazardous substance designations, PFOA and PFOS meet that standard listing. The scientific evidence around the toxicity, persistence, and other shared characteristics of PFOA and PFOS make it indisputable that these chemicals meet this standard. While the designation of these substances is indisputable, the implementation, which will involve treatment and remediation of PFOA and PFOS contaminated sites, will be difficult but necessary. The absence of CERCLA hazardous substance designations makes it hard for impacted communities to identify PFAS releases and to recover their cleanup costs from responsible parties. And when releases are not reported and remediated, PFAS contamination spreads faster than it can be detected, leaving more communities exposed to these toxic chemicals and placed at greater risk of harm. Therefore, it's critical that EPA lists PFOA and PFOS at minimum as hazardous substances under CERCLA to protect communities. And throughout my presentation, I'll walk through the scientific evidence behind the indisputable dangers of PFOA and PFOS and other related PFAS, starting with the background on the broader class of chemicals. Next slide, please. So PFAS stands for per and polyfluoroalkyl substances, which encompass an expansive class of chemicals. There are over 12,000 known PFAS, and this list is growing. This class includes long-chain PFAS, short-chain PFAS, fluoropolymers, and precursor compounds, which degrade to long and short-chain PFAS in the environment. And this is by no means an exhaustive list. Overall, this class is comprised of structurally diverse compounds. However, the chemicals within this class share many characteristics. For example, all PFAS are characterized by carbon-fluorine bonds, which I've shown in the diagram below. This is one of the strongest chemical bonds in existence, rendering most PFAS virtually indestructible in the environment, particularly those with many carbon-fluorine bonds. In fact, some PFAS can take thousands of years to break down in the environment. And this characteristic is broadly referred to as environmental persistence. Many PFAS are water repellent and are used as nonstick or water repellent coating on raincoats, nonstick pans, and certain food packaging. PFAS are also found in cosmetics, textiles, building materials, and other consumer items. And for years, PFOA and PFOS were used in aqueous film-forming firefighting foam, which is a mouthful and is pictured here. Because of their persistence in the environment, PFAS are also highly mobile in most environmental media, including air, water, and soil. And their persistence also renders most PFAS difficult to metabolize in living organisms. And as such, many PFAS will bioaccumulate or build to high concentrations in living organisms once ingested. Next slide, please. I wanted to provide a brief background on PFOS and PFOA, the two PFAS that are relevant to the CERCLA proposed rule. So these two compounds are two of the most pervasive members of the PFAS class. Both chemicals, as shown in these 3D chemical diagrams, are characterized by a long chain carbon backbone, which is shown in gray, and many carbon-fluorine bonds, and fluorine is indicated in green. Both chemicals are highly persistent in the environment and in the human body, and they have long half-lives, or the time required for a chemical to break down to half of its initial load. The half-life of PFOA in the human body is up to 10 years, and the half-life of PFOS in the human body is as high as 27 years. These chemicals have also been around for a while. Both of them were initially developed by the chemical company 3M in the late 1940s, and both are highly toxic to humans and wildlife. For decades, scientific evidence has shown that these chemicals pose serious health risks to people, including multiple types of cancer, liver disease, autoimmune disorders, and other serious harms, which I'll get into next. And EPA has also known about these risks for decades, and yet these chemicals remain largely unregulated under CERCLA and most other federal environmental laws. Moreover, because of their extreme environmental persistence, the number of decades that they've been produced and disposed of in an unregulated fashion, and their ability to accumulate in living organisms, PFOA and PFOS have been detected in nearly all people living in the United States through large-scale biomonitoring studies. And as such, these chemicals are an urgent public health and environmental issue facing communities across the United States, and they certainly present a substantial danger to public health and the environment. Next slide, please. PFOA and PFOS are considered the most well-studied PFAS, and for decades, scientific research has underscored their toxicity and indisputable danger to human and ecological health. Hundreds of studies have linked these chemicals to a range of health effects in people, including certain types of cancer, namely testicular cancer and kidney cancer, endocrine disruption, increased cholesterol levels, immunosuppression, reduced response to vaccines in children, and several developmental harms, including low birth weight and delayed mammary gland development. The health risks from PFOA and PFOS are well established and broadly recognized by international organizations, federal and state regulatory agencies, and leading scientific bodies. For example, the International Agency for Research on Cancer, or IARC, concluded that PFOA is possibly carcinogenic to humans, and EPA concluded that there was suggestive evidence of the carcinogenic potential of PFOA and PFOS in humans. Increases in testicular and kidney cancers have also been observed in highly exposed communities in the US. And many of these health effects can result from extremely low levels of exposure. EPA recently updated its toxicity assessments for PFOS and PFOA and found that they harm children's immune systems and reduce vaccine effectiveness at extremely low exposure levels in the parts per quadrillion range. Those assessments were based on hundreds of studies that were published in the last 10 years. Accordingly, EPA updated its drinking water health advisory levels for these two compounds, PFOS and PFOA, to levels 3,500 and 17,500 times lower, respectively, than their previous levels. And because these studies found health risks below most laboratories' detection limits for these compounds, EPA warned that any detectable level of PFOA and PFOS places children's health at risk. Therefore, particularly when persistence, mobility, and the capacity for bioaccumulation are taken into account, any release of PFOA and PFOS may present substantial danger to the public health or welfare or the environment. Next slide, please. So PFAS can enter the environment in several ways, including from the manufacturing, processing, use, and disposal of PFAS and products that either contain PFAS or generate PFAS as a waste byproduct. Disposal includes processes like incineration, which seldom destroy PFAS and rather can generate new PFAS or release existing PFAS into the air. In addition, PFAS precursors that are emitted or released into the environment via these pathways can biotransform into other PFAS, including long-chain PFAS like PFOA and PFOS. And because of their environmental persistence, PFAS released into the environment linger for decades or longer and contribute to legacy exposures for years after their initial release. People are then routinely exposed to these chemicals from multiple sources, including their water, food, and consumer goods and materials that they use or contact. And PFAS exposure also occurs inside homes through treated furniture and rugs, cookware and cleaning supplies, and even inhalation of household dust particles that contain PFAS molecules. One study found that over 90% of US household dust samples contained PFAS, including PFOA and PFOS. Next slide, please. So as a result of their chemical characteristics, widespread use, and limited regulation of their manufacture, disposal, and release into the environment, PFAS are now pervasive environmental contaminants and have been detected in all environmental media and most people living in the United States. And all environmental media includes air, soil, surface water, drinking water, and even rainwater. Next slide, please. To provide an example of the widespread environmental PFOA and PFOS contamination in the United States, contaminated drinking water is a really relevant pathway of concern. A 2020 study found that over 200 million people living in the United States likely drink water polluted with levels of PFOA and PFOS that are well above the new EPA health advisory levels. This means that most people living in the US are drinking water that is contaminated with hazardous levels of PFOA and PFOS. The widespread nature and level of PFOA and PFOS contamination in US drinking water systems really underscores the substantial dangers that these chemicals pose to public health. Next slide, please. So depicting this contamination crisis, the Environmental Working Group, or EWG, has mapped PFAS contaminated sites across the US, including 50 states and 2 US territories, which are not shown here. As of June 2022, EWG identified 2,858 known PFAS contaminated sites, which includes drinking water sources shown in blue dots and military sites shown in purple dots. And this map clearly highlights, the failures of EPA to protect us from PFAS and highlights clear opportunities for taking action, for example, under CERCLA. Next slide, please. To make matters worse, persistent chemicals like PFAS can travel to the Arctic and polar regions through a process known as global distillation, or the grasshopper effect. So through this process, persistent chemicals that are emitted to the air or enter the water from polluting sources thousands of miles away from the Arctic are picked up by oceanic and atmospheric currents and deposited in colder climates, eventually accumulating in the polar regions, including the Arctic and Alaska. Because of global distillation, persistent chemicals like PFAS are being deposited in Alaska and the Arctic at very high levels. Scientists have noted that their concentrations in aquatic ecosystems and in people inhabiting these areas are increasing over time and have reached levels that present a hazard to human health. Once persistent chemicals arrive in the Arctic ecosystem through this process of global distillation, they accumulate in living organisms and can increase in concentration up the food chain, reaching extremely high concentrations in larger animals like marine mammals, ringed seals, and polar bears, which contain some of the highest levels of persistent pollutants on the planet. Next slide, please. Some of these animals are integral components of the diets and cultures of indigenous peoples of Alaska and the Arctic. And the widespread presence of PFAS in these traditional foods means that Arctic indigenous peoples regularly ingest chemicals that are harmful to their health. The result is that Arctic indigenous peoples have some of the highest levels of chemical contamination in blood and breast milk of any population on Earth. A 2019 study found that PFOA and PFOS was in the serum of 100% of Alaskan indigenous people sampled who live thousands of miles from facilities that manufacture and release PFAS. And the serum PFAS levels were significantly associated with changes in thyroid hormone levels. Next slide, please. So coming back to the broader class of chemicals, to summarize, PFAS encompass a wide range of structurally diverse compounds with shared characteristics, including persistence, mobility, and bioaccumulation potential. And ongoing scientific studies suggest that many PFAS share the same toxicity endpoints as PFOA and PFOS. Next for animation, please. Thanks. So highlighted here is data from the PFAS Tox database, which is an initiative that highlights the hazard evidence for less well-known PFAS. As you can see, and it's a little bit small, but this data clearly demonstrates that emerging science underscores the substantial dangers of other PFAS. As shown in kind of this heat map, some of these chemicals have more than 100 studies examining a single health endpoint, as you can see indicated in the intensity of the color. Next slide, please. So the emerging consensus that PFAS share common characteristics, including toxicity, persistence, and mobility traits, as well as evidence that PFAS precursors can transform into long and short-chain PFAS in the environment, means that we can expect many PFAS to behave similarly in the environment and to exert similar dangers to human and environmental health. In some cases, scientists argue that this warrants a class-based regulation. Within the context of CERCLA, it is clear that PFOA and PFOS are not the only PFAS that present substantial danger to public health. And so accordingly, EPA should move forward expeditiously for designating additional PFAS, including PFAS precursors and other PFAS with toxicity classifications or established toxicity levels as hazardous substances by initiating a notice of proposed rulemaking. Thank you. I will stop there, and I look forward to the other presenters.
Rashmi, thank you very much. It's fascinating to hear about all of the science behind this. Just wanted to remind people that you can submit Q&A throughout the presentation, and wanted to follow up with one question for you, Rashmi. Given the kind of widespread exposure of the public to this, it seems like there may be some environmental justice concerns here. Could you discuss that?
Yeah, I'm happy to. So the evidence around environmental justice concerns is very much kind of emerging, but we know that from certain studies, particularly one conducted by the Union of Concerned Scientists, that almost 40,000 low-income households, and nearly 300,000 more people of color live within 5 miles of a PFAS contaminated site. And these communities, we know, are often burdened by other non-chemical stressors, such as psychosocial stress from experiencing racism or healthcare inequity or food insecurity, that increases their susceptibility to harm from PFAS. And we also know that contaminated drinking water is more common in communities that are kind of facing these non-chemical stressors. So putting two and two together, we know that there are budding and kind of emerging environmental justice concerns in terms of exposures from PFAS contaminated sites, and that can inform kind of more targeted action.
Thank you very much for that explanation. And I'm not seeing any more questions at the moment, so I will go ahead and turn it over to Simone for her presentation. Simone, I believe you're muted.
All right. Thanks, Leland, and thanks, Rashmi. I thought it would be helpful if we started this next section off by just sort of orienting everyone with, and next slide, please, Leland. Just orienting everyone with EPA's historical interest in PFAS, just so we can see just sort of the steps that EPA has taken regarding these substances over time. So in 2006, EPA invited 8 major leading companies in PFAS, in the PFAS industry, to voluntarily join in the Global Stewardship Program. According to EPA, it launched the program because it had concerns about the impact of PFOA and long-chain PFAS substances on human health and the environment, including concerns that EPA had about persistence, presence in the environment, and in the blood of the general US population, as well as the long half-life in individuals, which Rashmi spoke a bit about, and developmental and other adverse effects in laboratory animals. So the stewardship program had 2 goals. One was for the participating companies that were participating voluntarily to commit to achieve no later than the year 2010, a 95% reduction measured from a year 2000 baseline in both facility emissions to all media of PFOA, precursor chemicals that can break down to PFOA, and related higher homolog chemicals and product content level of these particular chemicals. And the second goal of the stewardship program was just for the companies to commit to working toward the elimination of these chemicals from emissions and products by 2015. All of the participating companies indicated that they met these goals. Several years later, in 2009, EPA's Office of Water established a provisional health advisory for PFOA and PFOS. And these values, as reflected on the slide, were 0.4 micrograms per liter and 0.2 micrograms per liter, respectively. In 2016, EPA established health advisory limits for PFOA and PFOS at 70 parts per trillion. Next slide, please. There's been a renewed focus on PFAS with the current administration. In October of 2021, EPA announced its PFAS strategic roadmap. And this 3-year-long roadmap sets forth specific actions that EPA intends to, quote, research, restrict, and remediate PFAS. And it also provides a timeline for EPA to achieve certain milestones using a whole of EPA approach. I'm not going to walk through each one of these goals and objectives of the roadmap, which are displayed on the right side of the slide, but I wanted to call your attention to several of those. The first, and it builds off the question that Rashmi received from the audience, just deals with environmental justice. The roadmap states that EPA will conduct research to understand how PFAS contribute to the cumulative burden of pollution in communities with environmental justice concerns. For those keeping track of just EPA guidance and sort of actions, you'll notice, I'm sure there are a couple of different phrases that stand out to you. One is cumulative burden, and the other would be environmental justice, both of which have been expressed goals to address by Administrator Regan in the current administration. So it follows then that the administration is going to focus intently on cumulative burden or cumulative impacts and environmental justice as it deals with PFAS or alleged PFAS contamination just generally. The roadmap also states that EPA will use and harmonize actions under all available statutory authorities to control and prevent PFAS contamination and minimize exposure to PFAS during consumer and industrial uses. Along these lines, EPA announced that it is developing a proposed national drinking water regulation for PFOA and PFOS. The proposal will include a non-enforceable maximum contaminant level goal, as well as an enforceable standard, a maximum contaminant level. EPA anticipates finalizing the rule this year. If the rule is finalized, this would, for the first time, limit the amount of PFAS that's allowed to be released into drinking water at the federal level. Under the remediate goal, the roadmap states that EPA will, among other things, maximize responsible party performance and funding for investigations and cleanup of PFAS contamination, which is why we're here today, the subject of today's discussion. And as I will discuss shortly, and Lynn, I'm sure is going to cover in more detail later in the presentation, this includes designating PFAS as a hazardous substance under CERCLA, the Comprehensive Environmental Response, Compensation, and Liability Act, which I'm sure you all know is also known as Superfund. Last year, and this is just the final point that the slide makes, EPA published its lifetime health advisory levels for PFOA and PFOS. The levels are 0.004 parts per trillion and 0.02 parts per trillion, respectively. Although these are advisory levels, which means that they're not enforceable, nor are they regulatory, they are featuring prominently just in state activity, which where the states generally, or sometimes at least, base their regulatory activity on direction from the federal government. And these levels are also featuring pretty prominently and sort of buoying in some respects the proliferating litigation as evidence of PFAS harmful effects. Next slide, please. Late last year, EPA issued a notice of proposed rulemaking to designate PFOA and PFOS as hazardous substances under CERCLA. Notably, the proposed rulemaking is EPA's first time employing its power to designate new chemicals as hazardous substances under CERCLA since the law was enacted. If the rule becomes final, there are a couple of things that we want to know. First, it will require that facilities report on PFOA and PFOS releases that meet or exceed the reportable quantity set under CERCLA. Currently, the proposed quantity is 1 pound or more in a 24-hour period. It's important to note that the entities would not be required to report past releases of these substances, since the chemicals were not yet listed as hazardous substances. It's also important to note that as proposed, the failure to report the releases would constitute a criminal offense. The rule also would require or force responsible parties to take remedial actions and also pay for the cleanup of a contaminated site. I wanted to draw your attention, even EPA acknowledges that it does not have the authority to exempt particular entities from liability. However, the agency has indicated that it's prepared to address these types of concerns with certain enforcement tools that it has at its disposal. These tools may include the issuance of new policy documents, such as a policy that discusses enforcement discretion of the agency and also some settlement agreement. As the slide indicates, a final rule is expected in August this year. Next slide, please. So, as I indicated, oftentimes the federal government's actions actually tend to spur or to reinforce actions that the states are taking. The same is true here. The federal government is interested in regulating PFAS. The states are as well. And this slide just details or lists some of the actions that the states are taking. One of them would be drinking water standards. A number of states, quite a number of states, have taken steps to limit the presence of PFAS in drinking water. A number of states also are taking steps to eliminate PFAS in all different types of products, from consumer products, textiles, and other types of products. And then what we're also seeing is just attorney generals filing suits against companies because of alleged PFAS contamination. So with that, I will turn it over to Lynn.
Simone, thank you so much. And just perhaps you or Lynn, as we jump into it, there's one pending Q&A question. I don't know if we want to touch on it now or later, but I guess since PFAS is somewhat narrowly regulated at this point and absent regulation of PFAS as a class, would it make sense to prioritize regulating precursors of PFOA or PFOS under CERCLA? We can save that to later or throw it to either of you now.
I'm happy to weave it into my comments, if that's all right, Leland, and then perhaps
That
during our
works great.
roundtable.
But thank you very much, Simone, and thank you, Lynn, for taking over.
Thank you, Leland, and my thanks to my colleagues and to Madison for organizing this webinar. It's always a pleasure to be here and to be working with ELI. I'm going to be covering the commercial, business, and legal kind of implications of this proposed rule. As we heard from Simone, it is, of course, a proposal. And according to the regulatory agenda, EPA is expected to take final agency action sometime later this year. August is specifically listed. I suspect it might drift to the end of the fiscal year. And although this is the first time EPA is seeking to exercise its authority to list under 102 of CERCLA, to my eye, and based on a review of the 630 or so comments submitted to the public docket, I would imagine that this will largely be issued in a final rule just as proposed. But we shall see. I have two, next slide, please. I have two slides coming up that kind of reflect the general angst of the regulated community over this rule. I had originally wanted to use the iconic 1893 Edward Monk, The Scream, because this is kind of a general freakout rule because of the very significant, very consequential implications of these listings. The Scream, as you know, was intended to reflect the anxiety of the human condition. And I think based on what we have heard thus far, there is lots of reason to be very, very concerned, given the ubiquity of PFAS substances in all environmental media and throughout the globe. And also to the consequential regulatory implications of this specific proposed rule, which I will be getting into. Next slide, please. This is kind of another way of looking at it for those of you that practice in CERCLA and RCRA remediation, for those of you who are transaction lawyers, for those of you that have any dealings with real estate, this is a huge, huge development. And that big tsunami kind of depicted in this slide, while whimsical and comical, is pretty accurate. Because those of us that will be trying to evade responsibility and liability for the consequences of the ubiquitous nature of PFAS contamination around the world will be a very protracted, time-consuming, technically, from a policy perspective and a federal and state regulatory perspective, very, very complicated. Next slide, please. What I'll focus first on are just, what will this mean when the rule is issued in final with regard to contaminated Superfund sites? it will come as no surprise whatsoever that once these contaminants are listed as hazardous substances under CERCLA, it will significantly, in my view, extend the time, the duration, and the specific nature of the remediation efforts underway at active Superfund sites. I did Superfund years ago when I began my career, and this is kind of triggering post-traumatic stress syndrome, because the complexity of Superfund cleanup actions, although more mature now than when the statute was first implemented and amended in 1986, there continue to be significant allocation, causation, speciation, and related issues that are just going to become immeasurably more complicated now with the inclusion of PFOA and PFOS. There will be a dramatic increase in the number of designations of new Superfund sites, not surprisingly, because these contaminants have not heretofore been identified as hazardous substances for CERCLA remediation purposes, and because of their ubiquity as specific chemical substances, PFOS or PFOA, not the inclusion of the 12,000 plus or 9,000 as CDC notes, plus PFAS substances. We can just expect a lot of new designations of Superfund sites. You saw on Rushme's slide all of the sites that have been identified by EWG, and that's what we know now. Importantly, also, since 1986, when the Superfund amendments were issued, any settlement agreement with EPA requires a reopener provision, which means if there are newly identified contaminants or contaminants that might have been not newly identified, but newly identified at a site because of new analytical methodologies or just new information generally, it could trigger a reopener of what had been considered a settled, kind of cleaned up site. So you can expect a lot of reopener provisions to be activated here, and that invites considerable unrest, uncertainty, and financial, just a huge financial question mark regarding what one's financial responsibility for CERCLA liability might be at any particular site. Because remember, as my colleagues have already indicated, under Superfund liability is joint, several, and strict. So the uncertainty of all of this is just causing quite a lot of disarray in the regulated community. It's possible, but I don't want to speculate that I don't think it's likely, but it is definitely possible that the inclusion of PFOS and PFOA on the list of hazardous substances for CERCLA remediation purposes might also potentially cause redeveloped sites to be reopened, right? I mean, and I think in that regard, EPA's commitment to environmental justice, the proximate nature of a contaminated site to other areas could well cause, under some certain circumstances, revisiting redeveloped sites, however inconvenient and disruptive that would be. If human health dictates that result, that is a very distinct possibility. And finally, could definitely complicate ongoing settlement negotiations based on all of the things that I've already mentioned, the vagaries of detection methodologies, what remediation technologies might be best suited to PFOS and PFOA, and related scientific and procedural uncertainties. So there's just an awful lot that we don't know, what cleanup standards might apply, what allocation schemes might apply. I suspect very strongly that there won't be any type of a universal cleanup standard. It could be a site-by-site standard. So just the lack of certainty, the open-ended nature of what remediation technology might apply, what is a cleanup standard that might apply, who's going to be in, how do we get these people at the table? These are all circumstances that people are thinking about right now, but certainly have no means of addressing until the rule is issued in final. Next slide, please. So who all might be involved in this? Well, the usual cast of characters considered potentially responsible parties under Superfund. Those are entities that manufacture, process, and or treat, store, or dispose of these substances, could be deemed PRPs at CERCLA sites, and thus face assertions of joint, strict, and strict liability. EPA, as a consequence of this new rule, when issued and final, would have new authority to order cleanups under CERCLA 106. They could recover, EPA could recover cleanup cost under CERCLA 107. Private entities that have contributed to a cleanup could bring private cost recovery actions under CERCLA 107 or actions for contribution under CERCLA section 113. And for those entities that might ultimately find ways of evading this liability, just being brought into the CERCLA party historically has proven to be costly, time-consuming, and probably difficult to extricate oneself from an assertion of liability. Just recognize that, you know, even being part of an action could give rise to all kinds of adverse consequences with respect to, you know, your alleged participation in causing contamination at a particular site, whether it's soil contamination, groundwater contamination. These are very consequential assertions of liability, and extricating oneself from them is not easy or trivial. Next slide, please. You know, recognizing also, just even looking at the docket in this case, there's an awful lot of comments submitted by individual people, not trade associations and others, just a lot of widespread public awareness of the ubiquity of PFAS substances, and PFOA and PFOS being prime among them because of the legacy of those chemicals in other contexts. You know, motion pictures have been made about this contamination. So there's just great public awareness that already has been derivative of regulatory actions taken, but more will flow from additional identification of CERCLA hazardous waste sites throughout the United States, which will give rise to all kinds of reputational injury for those who are alleged to be PRPs at Superfund sites, will give rise to private litigation, as is already the case that we'll talk about in a minute. Could be heightened employee and worker concerns, like, gee, if you're a PRP at the Superfund site, are you still using these substances, these or other PFAS substances? And because of the nature and ubiquity of these substances, it's entirely possible that the answer to that question is yes. And for corporation shareholder scrutiny, derivative liability, shareholder responsibility, these are all concerns that are logically, to me, derivative of listings of these substances under CERCLA and all the other regulatory implications that will flow from that listing. Next slide, please. There are other regulatory implications that, again, you know, lists beget lists, and listing under CERCLA 102 beget other regulatory initiatives. As Simone and Rashmi both indicated, there will be reporting obligations derivative of releases of PFOA and PFOS and their salts and structural isomers in quantities greater than the default value of 1 pound within a 24-hour period. Reporting to the National Response Center is, of course, well understood now, but it will now apply to these substances. There will also be new obligations derivative of the Hazardous Materials Transportation Act because of the inclusion of these substances on the Superfund list enforced by the U.S. Department of Transportation. There are RCRA implications that are not directly derivative of the listing, but I did want to bring to everybody's attention, and I'm sure you probably already know, that there have been some 3 citizen petitions under RCRA to regulate PFAS generally, not just these 2 PFAS substances, PFOS and PFOA. But in 2021, the governor of New Mexico submitted a renewed petition to list all PFASs as RCRA hazardous substances, which is not going to happen. But what EPA did do was indicate its willingness to consider initiating a rulemaking to consider 4 PFAS substances, including PFOA, PFOS, and PFBS and Gen X, as hazardous constituents for RCRA 40 CFR Section 261 Appendix 8 purposes, which would begin if the agency initiates that rulemaking, which it is expected to do, would ultimately lead to the inclusion of these 4 PFAS substances on Appendix 8 of RCRA, which would begin ultimately their inclusion in RCRA Part 261 as listed hazardous waste. So it's a much smaller incremental step in achieving the goal of the petition that was submitted in 2021, and one was in 2029 and another, or 2019 and a third one in 2020. So stakeholders have long wanted the RCRA ability to consider these substances as hazardous constituents for RCRA corrective action purposes at treatment storage and disposal facilities, which that will come, but it's not directly relevant to this rulemaking. But I did want to at least make sure everybody is aware of the fact that there are activities underway in RCRA. There are OSHA HAZCOM considerations, although you wouldn't be required as a result of the HAZCOM requirements under that OSHA enforces. I can imagine entities wishing to note on their safety data sheets that these 2 substances are now regulated as hazardous substances for CERCLA purposes. Once this rule becomes final, federal agencies wishing to transfer property that had either a release or a storage of these substances, or you are aware of the fact that there was an historic contamination of these substances, would be required to note that under CERCLA Section 120H when transferring that property. So that disclosure requirement would mean obviously diminution in the value of that property and also trigger cleanup requirements. And of course, the inclusion of PFOS and PFOA on the federal list of hazardous substances could require the inclusion of those substances in certain state Superfund laws by operation of law. In other words, many states simply replicate the list that is maintained by the federal EPA under CERCLA. And so the inclusion of these as hazardous substances at the federal level would automatically make them amenable to cleanup standards under state Superfund acts. So in short, there are many, many consequences that at the regulatory level that this final rule, if issued later this year, would inspire. Next slide, please. You know, unsurprisingly, this is going to have huge implications for you insurance mavens out there. I am not one of them. Insurance is to me a vastly complicated area. But I'm certainly aware of the need for those of you that are in this space, and for any corporate client or trade association, you should be urging your members to evaluate existing insurance policies right now, because many of these policies are dependent upon knowledge and when certain releases happen. So it would be a good time to be mindful of the impending nature of this rulemaking and its probable effective date later this year to evaluate those policies sooner rather than later. Entities should be assessing opportunities for triggering any type of indemnification if it's part of a transaction. If others might be partially or wholly responsible for historic releases, you might want to avail yourself of those contractual protections. I would expect that insurers would be inclined to seek to limit their exposure for cleanup purposes. And I would expect to see an increase in the number of denials of coverage, which will invite litigation, as has already been the case. There's a lot of insurance litigation now interpreting comprehensive general liability policy provisions, and in particular, the exclusion for traditional environmental pollution. There are a couple of cases out there, Colony Insurance v. Buckeye being one of them, that kind of goes into whether or not PFAS exposure that has given rise to bodily human injury might be considered a traditional environmental contaminant. In that case, the court said, no, it's not traditional, and required the insurer to make good on their duty to insure. But I would imagine in other jurisdictions, in other contexts, that is going to be a hotly litigated provision. So lots and lots of insurance implications. Next slide, please. You know, for those of us that do engage in a lot of due diligence on behalf of private equity companies, transactions of all sorts, I cannot emphasize strongly enough the need to be very, very, very diligent in your due diligence and product stewardship initiatives generally. I know our clients are now beginning to ask an awful lot of questions, not just about PFOA or PFAS, but PFAS is generally the entire universe of them. And it's having a lot of implications in supply chain transactions, in mergers, acquisitions, spinoffs, whatever. So I would imagine now and going forward, there is going to be far more disciplined and very rigorous interrogations regarding the nature of PFAS in products, PFAS contamination generally, not just limited to these two constituents, because EPA can be expected to add to the number of listings under Superfund. And so if you're going to be looking for PFOS and PFOA, you're going to be looking at the whole shoot match. There's going to be far more granular understanding, or there should be much more specific understanding of the compositional components of any products that you are manufacturing. So querying your upstream suppliers, are there PFAS in this composition? If so, what is it? What species is it? At what concentration? Where did it come from? And if you are sending a product to a downstream customer, you can expect similar interrogation regarding the compositional elements of the materials that you are providing them. Reps and warranty provisions are now going to be much more specific when viewed broadly in the context of PFAS contamination. Site assessments, whether you're looking at ASTM, phase 1, phase 2, are now going to include much more specific attention to PFAS and where, in what media, what type of speciation, at what concentrations. And as noted, I would expect far more supplier certification requests from upstream and downstream suppliers generally. We can talk some more about what the future holds with regard to this very consequential rulemaking. And before I turn it back to you, Lynn, I would urge all of our listeners to actually read the proposed rule. I think EPA did a really, really good job in laying out why it's doing what it's doing, what its consequences are, and what many of the states that are already engaged in one form or another of PFAS regulation. So it's a long rulemaking, but a very well-written one, and we would all benefit from reading it. And as I said, there are about 650 comments that were submitted on it, most of them very supportive of the initiative. And I would expect a final rule to be coming out later this summer, or at the very latest by the end of the fiscal year. So Leland, I will turn it back to you.
Well, thank you very much. It sounds like we all have a lot to talk about. So I'm glad there's some roundtable time here. There's one question that has come in that Simone has flagged, so I'm going to kind of turn that over to her first. I think the general impetus of that question is, should EPA be waiting on more information before it continues with the rulemaking based on kind of the limited scientific information and the high impacts here? So Simone, would you like to address that question?
Sure. Okay, sure. And it probably won't come as a surprise that Rashmi and I may disagree on this point, but I think that EPA should wait until it has additional information regarding the alleged health impacts to more comprehensively attempt to regulate PFAS substances. Notably, there is not, to my awareness, a single epidemiological study that has found a causal effect between PFAS and alleged adverse health effects. So I don't think that it's a situation where EPA or the government needs to rush and sort of to rush rulemaking and rush regulating PFAS, is because the science just does not exist that conclusively links PFAS exposure with any adverse health impacts. I think at most that you're going to find is some type of alleged association.
Thank you very much. Rashmi, would you like to respond to that, or?
Yeah, thanks. I just want to quickly respond. Thanks, Simone. I do disagree. with that, so with regards to kind of causation and correlation, when it comes to epidemiological studies, the nature of those studies will never show causation. They will almost always be correlative. And there's a lot of very strong evidence from epidemiological studies that incredibly low levels of these compounds, PFOA and PFOS, are associated with really catastrophic health effects in children. So the EPA health advisory levels are based off of studies that found a reduced response to vaccines in children, antibody production in children following vaccination, which means that low levels of these chemicals are actually preventing us from developing, responses to vaccination. You can imagine the implications that that could have in the current global pandemic. The scientific evidence, in animal studies has existed for decades, in which you can kind of show causation and causative relationships between exposure and health outcomes. So I do think that there is enough evidence, and I think that has been confirmed by federal agencies, EPA being one of them, where they took, the very concrete step in relying on epidemiological studies to underlie these health advisory levels, which is really kind of in my opinion, a scientifically rigorous assessment and approach.
Thank you.
May I jump in for a minute?
Sure, yeah.
Two things. I wanted to respond to the question that I carefully didn't respond to when I gave my remarks, and that is the person's question regarding whether precursors might be regulated in the absence of broad federal or state PFAS regulation underway now. I think I would maybe turn that around a little bit to think that the PFOA and PFOS, not precursors, but derivatives might be considered for regulation. And that invites the second kind of comment I wanted to raise, which is whether or not the agency has significant information and information sufficient to list PFOA and PFOS is a different inquiry from regulating all PFAS substances, all 12,000 or 9,000 or, the thousands and thousands and thousands of substances out there that fall generally into this very broad category or definitional bucket of PFAS substances. I think that's a more difficult question. I think the answer is no. Of course, EPA doesn't have sufficient information on each of the chemical substances included in that class. And so the struggle that EPA, Europe, and other regulatory bodies are dealing with globally is how to prioritize those, right? And so the listing under CERCLA of PFOS and PFOA strike me as logical starting points for a much harder task of prioritizing how best to go about identifying and regulating substances, not because of their inclusion in a broad class, but to identify those that are thought to be the most toxic upon human and environmental exposure. And chemicals like PFOS and PFOA that are C8 and higher in carbon chain length do have a basis for concern with regard to chemical toxicity. And I'm presuming that is why the agency is beginning their listing with those two substances as opposed to the whole shooting match of PFAS substances. So back to you, Leland.
Well, thank you. So we've got a number of questions coming in. I'm going to try to combine some of them. I'm going to start with one that hopefully has a short answer for us to give, and it is, do comments to EPA make a difference? And if so, how do you submit comments to EPA? And I'd say perhaps as a general matter, specific, unique comments do make a difference. And I believe the current comment deadline is February 3rd, unless it's been extended, and you can probably Google and find a way to submit that to the EPA's docket. But I'll let any of you add your thoughts on that as well.
Yeah, I thought the comment period closed already. Was it extended, Leland?
So I don't know. I thought it was February 3rd, but I could be wrong. So hopefully someone knows more than me about that. But if not, so I think the general answer is comments do matter if you're willing to take the time to do specific, unique comments.
They certainly do matter, and EPA takes them very seriously, as they must under the Administrative Procedure Act. And as noted, there were a fair number of individual concerned citizen comments in addition to the usual class of characters. Yeah, I thought the comment period closed on November the 7th, but I could be wrong. Perhaps it was extended, but the agency has already received a lot. And if the agency intends to issue a final rule by August, which it claims to be in a position to do based on the most recent regulatory agenda, getting more comments at this late date would be challenging.
Yes, yeah, I think there was a petition to extend it, but it may have been denied. So that it could be that it's already closed. So thank you for that clarification, Lynn.
Yeah.
So there are numerous questions here about, can these be regulated at the state level? Do the states have enough scientific expertise to do this? How's the Department of Defense going to be regulated? Does Congress need to step in? Can you all kind of discuss kind of in general, what that broader regulatory framework looks like between states, Congress, EPA, and I guess obviously there are some Department of Defense implications here. So I'm lumping a bunch of questions together, but I think they all kind of apply to what is the best or practical regulatory framework for addressing this.
So before I might turn it to Lynn and Simone to talk about the regulatory and legal aspects of this question, but regarding the scientific part of this question, yes, anybody and everybody, all scientists kind of have, at least especially kind of working for state governments, should have access to scientific studies that are kind of required to undergo systematic review, and in that systematic review process, identify health endpoints of concern. I don't think this is something that has to be restricted to the federal government, as long as you have kind of access to scientific journals and scientific studies and have the tools and technology available to conduct a comprehensive systematic review. You should be well equipped enough to kind of identify endpoints of concerns and come up with those toxicity levels.
Simone, did you wish to jump in?
You can take it, Lynn.
Well, you're mushing together, Leland, the questions that you have invites a very long response, and I'm going to try to be very brief, but there are so many initiatives that have been invited as a consequence of the concern with PFAS generally at the congressional level. A couple of years back, under the NDAA, the National Defense Authorization Act, EPA was required to issue a rule under TSCA that requires entities that manufacture, import PFAS substances generally, as defined in that rulemaking, which includes thousands of rules, to engage in a one-time reporting obligation. So Congress already has engaged in that regard. That TSCA 8A7 rulemaking is expected to be issued in final this spring, which will invite a laundry list of people reporting on a one-time basis their engagement with PFAS, looking back the past 10 years. Again, that's a congressional requirement that mandated that EPA issue this rulemaking. There are a ton of states that have already engaged in their own rulemaking initiatives, largely relating to the inclusion of PFAS in consumer products, packaging, biosolids, cosmetics. So, Maine, New York, California, Pennsylvania, all have separate state reporting obligations and ultimate phase-out requirements for the inclusion of PFAS, again, defined broadly and disparately, in consumer products in particular. Some of them are notification requirements, others are ultimate phase-out of the inclusion of those in products. There's just a lot of state initiatives that are derivative of the concern with PFAS generally, but there's nothing kind of consistent or aligned with state initiatives, federal initiatives, and the congressional initiative that I indicated previously. So we can expect just a lot of action in this regard for many years to come, which will invite the litigation and the business concerns and ultimately all of the consequences that I talked about. But I also, and before I stop talking, want to look at the brighter side here. The inclusion of the chemicals on the Superfund hazardous substance list will invite greater detection methodologies, greater innovation in cleanup strategies. In the Tosca area in which I work, the concern with PFAS substance is inviting just a great deal of innovation in non-PFAS based substances that try to include the functionalities that PFAS substances are known to promote, but without the PFAS part. So, I mean, there is an upside here, and it's not just all bad, bad, bad. I think we also need to focus on the opportunities to eliminate substances that have a known nexus to environmental or human health hazard and risk, and recognize the important contributions to science, innovation, and new chemicals that these concerns are inviting.
Thank you very much, Lynn. We're getting in several here about like CERCLA and Superfunds and things of that nature, and kind of given the magnitude of contamination, it seems like potentially everyone could be liable. EPA has enforcement discretion. Kind of what are the implications for Superfund sites, for people all connected to that, or transportation of water or things of that nature? Are there other tools that EPA has? Will Congress need to step in? So kind of a general, how do we handle this under a CERCLA Superfund lens? Simone, would you like to take that one?
Sure. I think the concern that EPA's actions relative to PFAS generally, PFOA and PFOS more specifically, do create broad concerns. I mean, they do have the potential to impact all folks at all, or entities at all different parts of the supply chain. Recognizing that CERCLA imposes strict liability, obviously on current or past owners of facilities, then there's also the concern that manufacturers of PFAS are not generally captured as part of that liability, right? But it does sort of leave water operators, water operators at risk for PFAS contamination, especially when you're looking at, especially when you're just sort of considering that PFAS substances are ubiquitous. And when you sort of look at the health advisory limits that EPA just, or recently, I guess last year, established, and just how low they are, you are putting a lot of different folks, water suppliers, landfill owners, all at potential risk of liability as a result of some of the actions that EPA has taken.
Thank you very much, Simone. Rashmi, I think this next group of questions I'm going to ask maybe for you. There are a number of questions coming in about, are there studies that show impact on animals? Are there marine life implications? Have there been cost benefit studies done? Are there ways to regulate PFAS chemicals with like health impacts on animals or the environment if it hasn't been well established in humans? So kind of a general, what are the implications here? We know they potentially affect humans or do affect humans. Are there other environmental implications here that should be taken into account?
Yes, thank you for the great questions. I think the more and more studies that come out on this topic, the more disturbed I am. But yes, plenty of studies kind of finding PFAS in aquatic organisms, as I mentioned, including marine mammals in the Arctic. Recently, in the last year, there were studies published finding PFAS in bees that actually was associated with changes in hive behavior and survival in bee colonies. There was also a study that found PFAS in peregrine falcons and that was also associated with altered thyroid hormone levels. So these chemicals are pervasive across different species, across different trophic levels, and they're showing up all over the world, especially coming up in aquatic organisms in the Arctic, thousands of miles away from their original release sites, again through this process of global distillation. So yes, it's very concerning. And regarding taking action from a legal or regulatory perspective, I might turn that to Lynn or Simone, but I think there are several avenues that kind of could be pursued.
Well, and we are seeing those avenues being pursued as we speak. I tried to focus on what are the direct regulatory implications of a listing, a fairly narrow listing, I might add, of two substances, which are part of a much larger class of chemicals called PFAS, on the list of hazardous substances for CERCLA purposes. And because of their ubiquity, and the enormous popularity of PFOS and PFOA as synthetic chemicals when they were produced decades ago, under CERCLA, anybody who manufactures, processes, transport, or disposes of these chemicals could be held jointly, severally, and strictly liable for the contamination and human health consequences of exposure to those substances under CERCLA. So that is a, to me, logical and very broad brush approach to beginning to address the historic contamination derivative of those two chemicals. That's the beginning though, right? I mean, there will be other PFASs likely added to the list of hazardous substances. And just for closed or abandoned Superfund sites, right? So it's in that regard, this rulemaking initiative is narrow yet broad because of the ubiquity of the exposures and the enormous latitude EPA has under CERCLA 107 and 106, and private parties have under 107 and 113 to engage in litigation to recover their costs for remediating those cleanup actions. But, and given the other derivative implications and rulemaking authorities that the agency has at its disposal under the Safe Drinking Water Act, Clean Air Act, the Clean Water Act, TSCA, we talked about the 8A7 rule that applies broadly to PFAS, not just these two chemical substances. We can expect the federal government and state agencies and private litigants and others to engage in a whole host of actions to diminish and eliminate the inclusion of PFASs generally in products going forward. Whether that is a correct consequence or the right thing to do, I'm not going to go there because right now, if you are a PFAS, if you belong to that PFAS family, the consequences of that are all not good. And the broad nature of the definition of a PFAS substance includes chemicals that may not have any adverse implication or certainly no known or studied result or adverse implication, but because they're part of that family, by inference, they are believed to be not something that people wish to purchase or use in products, and certainly not what people will want to be seeking out, regardless of their functionality, just by virtue of their inclusion in this class. So the tip of the spear is just beginning, right? There are state consumer protection laws that are now beginning to be used to eliminate these substances in cosmetics, in rugs, and in other textile applications. There's just the entire arsenal of federal and state and private litigation is now being turned to identify, regulate, diminish, and eliminate PFAS substances, kind of regardless of what their toxicity or known human or environmental effect may be, simply by virtue of their inclusion in the class. And again, I'm not speculating on whether that's a good thing or a bad thing. I'm stating that as a matter of fact, that is the reality in the world today. And Simone and Leland and Rashmi, you may have a different view, but that guilt by association is like out already, and you're not going to put that toothpaste back in the tube.
Sure, and I think that's a fair point. And one of the things that Lynn mentioned earlier on is that right now the focus is on PFOA and PFOS, which are C8 homologs. And the thought was at least the C6 homologs were less toxic or not as toxic. But I think what we're going to see is sort of a fate, as Lynn mentioned right now, it's a very broad sort of net, all PFAS substances, to the extent that that's not successful, either because the technology is not there to sort of test for PFAS substances, just generally, or either because, to Lynn's point, that there have not been studies shown that sort of show a causal connection between PFAS substances and adverse health impacts. I think what we're going to see is sort of a phased approach. We're starting with C8 homologs now. I think that, C6 may be next and possibly C4. So I think that we're going to ultimately, to Lynn's point, the guilt by association, I think we're going to see all PFAS substances wrapped into that. And we're in the very early stages of sort of this what's going to be a long process.
Thank you. So I've got a question that's directed towards you, but it's pretty specific. For SDS, the safety data sheets, what should manufacturers, if anything, be doing to change the SDSs for PFAS generally, and then the listed PFOS and PFOA?
I had noted in my prepared remarks that I am unaware of any mandatory, let's say this rule comes out in August, and PFOS and PFOA are now listed hazardous substances under CERCLA. I don't believe that compels any mandatory amendment to one's safety data sheet. But as you know, companies have varying degrees and varying appetites for risk, and many entities may be prompted to include the listing of these two substances as appropriate on their safety data sheets as a voluntary measure. So safety data sheets are both a consequence of what one is required to disclose, and it's also an opportunity to put down information that you wish to disclose. And I can imagine some entities, including as a prudential prophylactic product stewardship initiative, listing PFOA or PFOS to the extent that is a reality, because as you know, these substances are no longer produced. So their specific listing on any hazard safety data sheet is probably unlikely, but the inclusion of those two substances, or perhaps other PFASs, may well be voluntarily added to a safety data sheet because an entity wishes to do so and not because they are required to do so. So I hope that answers the question, Leland.
I think that's a great answer. Thank you, Lynn. I think this is a question kind of for everyone. So for manufacturers and users of these substances, given all of the concerns generally, what should those manufacturers and users be doing? Are there alternatives that they should switch to? Should they just be warning the kind of end user, or like kind of generally, what advice or thoughts would you have for the kind of supply chain of PFAS?
So I can go first on this one, and then I defer to Lynn and Rashmi. I think it all depends on the type of PFAS substance that you are employing. I spoke about it earlier. I think Lynn touched on it too. A number of states, for example, are eliminating PFAS, I guess broadly, in certain products, cosmetic, consumer products, textiles. So I think one of the things you want to do if you're operating one of those states that's regulating these PFASs, you want to get an understanding of your supply chain. You may not be introducing PFAS specifically into your products or your sort of operations, but what if someone in your supply chain is, and sort of what are your liability or potential liabilities or responsibilities there if you are? If you are using PFAS, to the extent you're operating in one of the states that is prohibiting PFAS, I think California starts in maybe for certain products starts in 2025. You do want, depending on what those PFAS substances are, looking at alternatives. There are alternatives there depending on the qualities that you're trying to get in a product. A lot of times people are using PFOA and PFOS, for example, for their oleophilic or hydrophilic properties. So if those are what you're looking for, obviously find a replacement that can still give products those characteristics, those qualities. But I think you want to have obviously a firm understanding of your operations, as well as sort of inputs into your operations from other parts of the supply chain?
Yeah, I'll chime in on this question. So from a scientific perspective, really the only solution is to stop the flow of these highly persistent toxic chemicals into the environment. And I think that will require generating and relying more on alternatives. As I mentioned in my presentation, this carbon fluorine bond, putting our chemistry student hats back on, is one of the strongest bonds in existence. Fluorine is the most electronegative element, and that bond, it makes these chemicals virtually indestructible. There's similar bonds with other halogenated compounds like chlorine and bromine, and halogenated flame retardants is an example. These chemicals, they just stick around. They stick around for decades, if not centuries. They migrate to the poles. They build up in our plant systems, in our ecosystems, in aquatic organisms, in terrestrial animals, in us, right? Like there's literally not a human on Earth, I think, who does not have PFAS detected in their blood. Persistent chemicals need to be ramped down by the chemical industry, and that needs to be kind of a broad commitment and a very high scale commitment. Regarding cost implications, I can't speak to that, but from a scientific perspective, from a public health perspective, we have to stop generating highly persistent halogenated chemicals.
That's the question that you raised, Leland, is to me like the $64,000 question. And both Simone and Rashmi have provided super responses, and there's not a lot I can add to those. I think what I've been advising my clients is certainly to be aware of the compositional elements of your supply chain, because you really need to understand and define if you have a problem, whether you have one right now or you expect that you could have one down the road, given the greater and greater and greater public, regulatory, legal, insurance, and transactional attention being focused on the class of chemicals known as PFAS. So know your inventory, know your supply chain, and be in a position to appreciate whether compositionally products coming into your shop, products going out of your shop, have any of these substances in them. You need to then monitor and be keenly aware of all of the initiatives that we've talked about. This is an hour-and-a-half webinar. We could talk for days about the regulatory initiatives going on in the United States at the state level, what's going on in Europe, which banned PFAS in food wrap already, and states have similarly taken steps to eliminate opportunities for PFAS in media and substrates that could cause human health harm. But you need to be aware of what these initiatives are so you can protect your client, or if you're an in-house counsel, protect your company, or just to be generally aware of what's coming down the pike. From a manufacturer's perspective, eliminating these substances is easier said than done. Often formulations are very specific to the functionalities that a chemical imparts. And so whether there is a surrogate chemical that is approved and offers the same functionality often is very product specific. So you should begin thinking about substitution or elimination strategies to make sure that your product continues to be fit for purpose, because if it's not, then you're going to be inviting other commercial problems, like the product is no longer performing according to standard. If these are government products that are subject to mil spec, for example, like the aqueous film, firefighting foams, which have very significant and well-documented functionalities in terms of suppressing fires that are a chemical fire or very difficult to put out. While there are substitutes, they're not as efficacious. They're getting there, but they're not there now. And what are the implications of having products that are not as efficacious as they would be if they included PFOS or PFOA or other PFAS substances? So there's just a whole long analysis that companies need to be engaged in right now. What are your PFAS potential exposures? What's going on at the federal, state, and international level? And what should you be doing to account for and be mindful of the implications of these initiatives? Because just going about your business without giving any thought about the presence of these substances in your product and your supply chain is probably a pretty big mistake and could be a very costly one.
And just one more thing that I wanted to add that I forgot to add earlier. I know we paid a lot of attention to intentionally introducing PFAS substances into products. I think one thing that you want to get a handle on too is whether certain PFASs result as unintended byproducts, maybe from the manufacturing process. And I think another thing that folks should be cognizant of is just whether there's the potential for substances to break down or to degrade into people, or, you know, a PFAS, a regulated PFAS substance in the environment. So to the points that were made by Lynn and Rashmi, it's a very complex analysis, but it's one that the industry would be well served to start to get its arms around.
That's a really good point, Simone, because I had mentioned the 8A7 rule, which deals with intentionally added, the main reporting obligation that kicked in January 1 of 2023 are intentionally added, but there are lots of chemicals that might be derivative and incidental byproducts. And whether you are aware of those or not is another matter entirely. So that's a really good point, and I appreciate you raising that.
Yeah, thank you all. So that was a $64,000 question. This may be the $1 million question, and I see we're running out of time here, so this may be our last question as well. But what are the best ways to deal with or dispose of PFAS contaminated material, especially considering that incineration is banned in many places? Do you all have thoughts on, you know, we've got all this stuff, what do we do with it?
That's a really good question. And I know EPA struggles with that because incineration capacity is limited. There are probably questions about whether other remediation methodologies for eliminating or containing or solidifying or decanting or whatever liquid hazardous waste or liquid waste that contains PFAS are efficacious. So I do not purport to be an expert in that. All I know is that there are lots of really important questions that surround what do we do with these materials. I think incineration is thought to be the preferred option, but I'm going to defer to Rashmi and Simone. And I know that there are limited opportunities for doing that domestically at the federal level because there's just not a lot of incineration capacity.
Yeah, thanks, Lynn, and thanks for this really good question. This is $1 million question. I think there are, dozens of scientists around the world who are trying to tackle this problem. I think it touches at a couple of things. It's two issues, which is kind of capturing and sequestering PFAS that have already, been distributed into the environment, and then destroying PFAS, destroying that captured PFAS or destroying PFAS that is being disposed of by manufacturing or industrial processes. Both of those, I think, are ongoing scientific questions. EPA has kind of launched, I think, a contest on methodologies for PFAS destruction. We know that incineration is not really a safe method of destruction. It often leads to the generation of PFAS breakdown products, which are sometimes other dangerous PFAS. And it really often fails in actually destroying the PFAS compounds. As I mentioned, the carbon-fluorine bond is really difficult to break down, even from a thermodynamic perspective. And so through incineration, what happens is these chemicals just kind of get spread into the air further. So it actually is a very poor method of destroying PFAS. Coupled with innovation to capture PFAS from the environment, innovation to actually destroy PFAS, and commitment from chemical manufacturers to slow down or stop the production of fluorinated or highly fluorinated compounds, I think will kind of be the three-pronged solution. But obviously that involves a lot of time, a lot of money, a lot of science and commitment from multiple parties.
And I'll just add, to the extent that it's helpful, EPA did release some interim guidance on the destruction and disposal of PFAS. And so the guidance provides destruction and disposal technology alternatives for PFAS containing textiles and just waste generally. that was generated by facilities that manufacture or use PFAS. So to the extent that it's helpful, that guidance is out there.
Well, I think we are running out of time here. Lynn, do you have any closing thoughts, or I will wrap it up?
No, I think Rashmi's response was good. And Simone, where might attendees find that guidance? Is it on EPA's website?
Yes, it is. It was published on December 18th, 2020, but it is on EPA's website.
Great.
Yeah, it's 100 and some page document, and it walks through just disposal methods depending on the physical phase of the materials.
Right.
Yeah.
Well, Rashmi, Simone, and Lynn, thank you very much for this fascinating conversation. Like Lynn said, I think we could have talked for days about this, but it really is fascinating and deserves kind of an ongoing conversation. And thank you also to Madison and ELI for hosting.
Thanks, Leland.
Thank you all so much.
Thank you.
Bye.
Have a good day.